Good afternoon. This is Robert Ball, and thank you for joining the presentation this afternoon. Talking about finding the holy grail of data security and data privacy. There's been a lot of conversation about the two areas and can they live together, and it appears there are some ways they certainly can, and in this regulatory environment we're all living in now, they certainly will need to. I'm the Global Privacy Officer and Chief Legal Officer at Ionic Security. We are in the distributed data security cloud business, and we've been around for about 5 years and have quite a few large enterprise clients in the data security space, really attacking it at the data level in a new way to come at both data privacy, data security, and access control. So thank you for joining, and I will jump right in. I do need to give a disclaimer that the views I'm expressing today are mine and not those of my employer, Ionic Security. So how have we arrived here? I think that everyone probably on this that's watching this presentation is painfully aware, or at least very aware, of all of the hype that's out there and all the increased attention that we see around data breaches, data security, everything from potentially affecting our political campaigns to affecting the commerce that we conduct every day. I was looking at a recent survey conducted throughout the EU by Symantec, and it was talking about importance of factors that you look at when choosing a company to shop with or a website to use. And amazingly, delivering great customer service is 82%, delivering quality products is 86%, but keeping your data safe and secure is a whopping 88%. So people online are looking to make sure that their data is secure ahead of the quality products you may be delivering or whatever customer care you may have out there. The other aspect that we see is that the perimeter is disappearing. We have mobile, we have connected devices, we have the Internet of Things, we have the cloud. All of this is taking place outside of the traditional network that we have of the company or our entity, be it a financial institution, be it a healthcare facility, or a shopping site online. All of this is starting to happen outside of that, and data does not like to stay home. It likes to travel. It likes to be shared via email. It likes to be shared with supply chain partners, and it exists and it starts to move in and outside of your organization in ways that you couldn't even comprehend 5 years ago. There's also an ever-increasing globalization that continues to alter the landscape. As the cloud proliferates and e-commerce proliferates, there is no geographic boundary that's respected. We see this as a huge challenge in the EU right now with the coming General Data Protection Regulations, or GDPR, which go into effect in May of 2018. I'll speak more about that in a minute. Data does not stay within the geographic boundaries, even when countries want it to. And so you have to figure out ways to protect it and keep it inside that particular country, or at least limit the access inside that country. The EU, but even here in this country, the FTC, the banking regulators, insurance regulators, and others are driving an increased focus on the regulatory and compliance oversight relating to personal information, privacy, and security. And as we'll talk in a minute, the statutes and the regulations that are requiring data security and privacy are becoming more and more prevalent and with much sharper teeth, bigger fines for noncompliance, extended liability for breaches, enhanced notification requirements, and other that have really raised the specter of data security and data privacy from when it used to be in one section of the company, perhaps with the CISO or in the CIO organization, or on the privacy side with the chief privacy officer or the legal counsel. These are now board level and company-wide exposures that are being dealt with as the threat vectors enhance and the amount of data out there proliferates. I continue to hear the statement that the amount of data that has been created in the last 4 or 5 days is more than what was created from the beginning of time until about 2002. So as we see increased data analytics, the proliferation of data lakes and other ways to manage our business based on data, this risk only grows, especially when you start to talk about personal information, personal financial information, personal health information, and other similar types of information that's now out there in ways that we never contemplated before. Fortunately, we start to see some encryption techniques and some scalable key management solutions that are out there and available to start to address this ever-growing need to both secure data and to keep it private. So what do we mean by that? And as I hear conversations and as I go to seminars and hear others speak on data privacy and data security, and there are other talks that have been online here at Bright Talk about security versus privacy. So let's look into that and see, have a discussion about what that means. So again, as I look at the world, I think it's all about the data. And we have these two circles that exist out there. We have the whole idea of data security. And when we talk about data security, historically we've been talking about confidentiality, keeping the access to the data and the security of that data in a way that it cannot be accessed and compromised by outside parties who aren't supposed to get to it. We talk about data integrity, the ability to keep the data in the state in which it was created so that it's not altered or modified or corrupted by outside parties in ways that render that data to where we can't trust it anymore. And of course, there's always the idea of in data security of having it available when we need it. So if it's corrupted or if it's stolen or if it's wiped out, then it's no longer available. These days there are multitudes of discussions and issues around ransomware and phishing, and all of these are attempts to lock you out of your data, keep you from being able to get to your data, or corrupting your data, all in terms of trying to break through the security and really start to adversely affect your ability to keep your data private and within the walls that you want it in. And again, this goes back to where these walls that traditionally data security was done on the perimeter. I built a strong perimeter just like I put locks on my house and intrusion detection systems on my house and physical assets to secure the perimeter to keep people out. But once they break in, or once I have insiders who are authorized to be inside and they walk out with my data, Edward Snowden being the most notorious one that we are all living with today. They have the rights to my data. They walk out with it. It's in the clear, and now it can be shared, copied, and done whatever I want with it without having the ongoing protections of that data. And then if you look on the flip side or the other side, you start to look at privacy, and data privacy is increasingly a focus here. We're far from catching up to where the focus has been in Europe. In Europe, it is data privacy is a core and fundamental right that is in the original treaty that created all of Europe, back the Treaty of Rome in 1950. And so data privacy is precious to Europeans. That has come across, and that philosophy is now starting to permeate the United States in the way we view things, especially as more and more of our personal health information, personal financial information gets out there in the cloud, in the wild, and is shared across different different ways, whether we're shopping online, interacting with our doctors or medical providers, or interacting, doing online banking or other financial transactions online. And then, of course, with the proliferation of social media, there's even more and more of our data that is out there, pictures being shared, conversations being shared amongst people who we think we might have a confined area, confined group of people that are looking at our data, but we find out later on that it was being widely shared, far beyond what we ever contemplated and certainly would have given permission to do. So when we get to data privacy, we start to look at constraints that need to be placed around data in terms of what are the use limits, what is the notice that needs to go along with that, and what sort of consent do I need or do you need to give to someone to access and use your data, and what are the limits on that. In Europe, there is a growing right to be forgotten, right to erasure, that is embedded in the new GDPR, which comes into effect 19 months from now. Both of these concerns and both of these issues are sitting here in tandem and have to be dealt with more and more in a concerted and in a uniform way. So let's look at some of the relevant statutes, regulations, and standards that are starting, that have been out there for a while, and more that are starting to emerge. I've listed just a few of them here, and this is just a sampling of what is out there. In the United States, we have HIPAA and the related HITECH Act that covers all of for U.S. healthcare and covers and protects and requires the protection of personal health information. And most of the regulations under HIPAA are looking to address both the security as well as the privacy and access to this precious personal health information. And in addition to the federal HIPAA law, there are states such as Massachusetts that have their own HIPAA-like regulations covering personal health information. The FFIEC, the Federal Financial Institutions Examination Council, is a unified testing and audit body that covers banks and financial institutions and looks to be a concerted effort across the banks and financial institutions, be they governed by the the Fed, the OCC, the FDIC, credit unions, etc. So this is looking at financial institutions, and then the FFIEC is currently going through a lot of changes to update their security and privacy regulations to cover financial institutions. Not just in the federal side. The state of New York has recently issued a new regulation, a proposed regulation, which is actually out for comment right now, which will cover banks that do business in New York as well as insurance companies. And it specifically addresses cybersecurity, privacy, data security, and calls for a CIO for cyber to be named by these institutions. So there's one central person at that C-level in an organization responsible for data privacy and data security. In Europe, presently, you have the EU Data Directive, which goes back to the mid-90s and really started to set the standard 20 years ago for data privacy and data protection. And this law has changed and grown over the years. In about the year 2000, the safe harbor that many of you have probably heard about, talked about, read about, was promulgated under the EU directive to allow data transfers between the European Union countries and the United States. And many of you may have filed for the safe harbor with the Department of Commerce to be able to do these data transfers under either model clauses or binding corporate rules. Safe harbor was invalidated some time ago, a little over a year ago, and primarily on the basis of concerns in the EU over the Edward Snowden disclosures, Whether they got the facts right or wrong doesn't really matter. They invalidated safe harbor, and there was a time for quite a while where companies weren't certain could they transfer data to the United States out of the European Union, and how best to do that. A patchwork of protections was put in place that's actually being challenged right now in the nature of Privacy Shield, and Privacy Shield went into effect in August of this year. Coming soon in Europe, as a matter of fact, in May of 2018 it will be effective, is the General Data Protection Regulations, which will replace the EU directive. And the GDPR has 99 articles and covers all sorts of protections and requirements for data controllers, those companies that capture data and hold data on behalf of EU data subjects. And it also has coverage for data processors, and these are companies that process data on behalf of a data controller. And there are quite a few interesting aspects of GDPR that will impact a lot of U.S. companies who hadn't previously been subject to European data regulations. And for those of you in the United States who have global operations, or who, even if you don't think you have global operations, but you work with consumers or customers or other clients who have reach into Europe, you need to be very aware of the reach of GDPR, because you may be holding information on an EU data subject, or needing to hold information on an EU data subject here in the United States, and think you're safe, when in fact you're now going to be subject to the reach of the regulators in Europe. Likewise, if you're a data processor doing this on behalf of a data controller who has EU subjects, you will now be faced with having to comply with the applicable provisions of GDPR for your business, where you wouldn't have had to worry about that before. Why is this so important? Well, first of all, this is a perfect example of a new regulation that has a lot of teeth to it. Under GDPR, if you are not in compliance, you can be fined for up to 20 million euros, the greater of 20 million euros, or 4% of your worldwide revenues, what the Europeans refer to as turnover. So the penalties for non-compliance have gone up greatly, and I think under the EU data directive, they are more in the nature of €500,000 is the standard. So it's going from 500,000 to the greater of 20 million, or 4% of your worldwide revenues. There are also a growing number of standards that are being promulgated out there, and more companies, as they deal with their supply chain, whether they're vendors who are supplying services or products to an entity, are requiring their supply chain providers to be compliant with standards, the most popular of which is ISO 27001. There's also underneath, for cloud providers, there's a new standard called ISO 27018, which goes even further in terms of cloud security at the data level. For banking and financial institutions, there's Gramm-Leach-Bliley, the GLBA, which has safeguards and rules for the U.S. banking and financial sector. In Canada, there's PIPEDA, which covers data protection in Canada. So for those who have clients and customers and deal with folks in Canada, there's a separate regulation under Canada to be looking for. If you're in the retail space, you're handling any sort of credit card transactions or any other secure transactions, then you have to look at PCI DSS, all the PCI, the payment card industry data security rules that are covering, again, both data security, primarily security, but more and more so getting into the privacy side as well, in terms of what sort of consents and what you can hold. And then if you are dealing with the federal government, you are in instances either under a framework, NIST framework for dealing with government agencies or those dealing with the government and their data security and data privacy. And if you are applied under a program such as FedRAMP, FedRAMP has specific cloud security assessment and requirements and compliance requirements for those dealing with the U.S. government. So again, what do these all have in common? If you start to look, whether you're in the PHI for the personal health information space, looking under HIPAA, or whether you're under the financial institution space, looking under GLBA, or in the retail space, looking to do PCI compliance, you have security requirements that run astride all of these regulations, access limitations, requirements for encryption, and other ways to protect the data while you are holding it. In the GDPR in the EU, there's a concept of pseudonymization, which in addition to being a hard word to pronounce, is ways to mask the identity of the data in a way that it's not traceable or identifiable back to a particular data subject. There are also security requirements with respect to data integrity and data retention. If you're holding data on me as a consumer, you have obligations to make sure that that data is accurate, and if it becomes inaccurate for some reason, there's a obligation to correct that data and put it back to where and fix it to where it should be. Running right astride these security requirements are the privacy requirements, and again, these are privacy requirements are very familiar to those who deal in the EU, much less so to the United States, those working in the United States, but they're coming. There are use limitations, privacy requirements around use limitations that have to be applied in a contextual fashion at the time that you are looking to use that data. You can't set the process in place and then walk away. If facts change or your need to use that data terminates, then you have to update your policies and protect the data accordingly. Right beside the use limitations is consent, and there are all sorts of requirements in terms of what does constitute valid consent, opt-out versus opt-in, and ways to make sure that you have proper consent before you start using someone's data, or even after you've started using it with valid consent within an appropriate use, to be able to come back and either where the customer or person that owns that data withdraws their consent or doesn't allow you to use it anymore, or when your consent was a time-based aspect. If I was gathering your personal financial information to give you a credit score, I don't need to maintain that for too long past the time I've given you the credit score, unless I have, and this of course requires looking at the specific legal requirements, which sometimes are in conflict. There may be a data retention requirement on behalf of that provider, which gives them a right to maintain it, but only for retention purposes, not for further use. And then there are, in terms of the privacy, there are requirements about how you can collect the data. What data can I collect straight from a data subject versus what data can I collect from a third party, perhaps a rating agency, about you, and what are the ways that the requirements I have to follow relative to the type of data I want to collect, why I want to collect it, what I'm going to use it for, and when I'm going to use it. And then finally, the statutes, regulations, and standards have a lot in common around accountability. And especially in the EU, this is an area where the regulations and the standards and the requirements are increasing very, very quickly, and they're getting much, much deeper. And that is in your ability to prove to a regulator to a standards body, to your trading partners that you have contracted with to provide protections, that you have adequate records to show that you have complied with the security requirements, with the privacy requirements, and that you can prove that, and quite often that those will be auditable, where a third-party audit or review board or a trading partner review can come in and see and show that you have adhered to the requirements for both security and for the privacy requirements. Let me go to the next slide here. So the quest that we're on is aligning both security and privacy. And how do we do this? We now have these two concentric circles that have come together as one, and we have to tick off all of these requirements of confidentiality, integrity, availability for security purposes, use limits and notice and consent for privacy purposes. So what is the key here? And I would submit that one of the key pieces to ensuring that you can satisfy both of these requirements is to have a suitable way to control the access to this information. This is the key to achieving both privacy and security. And this access control needs to be data-centric. It cannot simply be perimeter-based security, because as discussed before, the perimeter is disappearing, the perimeter moves, and the perimeter may be one thing on a mobile device, it may be something completely different in an IoT setting, and it will altogether be different in the social media space, or as we get more and more into cloud computing. It needs to be full life cycle. As I noted before, the privacy requirements are not set them and forget them. You have to look at the use limits, you have to get the proper consent, and all of this has to be contextual and has to respect the fact that the data owner might come in and revoke that consent that he or she gave to you before. And that plays to the fact that they need to be dynamic. You have to be able to, if someone comes in and says, I gave you permission to put cookies on my browser before, I don't want to give you that anymore. I don't want those cookies. So now I have to apply a different set of standards to what permissions I had going into that. They also have to be contextual. Just because I give you consent to use my data does not mean that I've given you consent to use my data for every possible purpose. Consent, in order to be valid, has to be not only informed, but it has to be specific to the use limitations that you are asking for my consent. If I have been asked for my consent to use my data to facilitate a wire transfer or other financial transaction, and a bank under its Know Your Customer rules has to have a certain amount of personal information so that they can validate that transaction, that's one thing. And that exact same information cannot necessarily then be used by the bank to market to me different products and services of that bank, apart from the one I happen to be using in which I gave my original consent. So again, all of this has to be very contextual. It also has to be very transparent. There has to be ways to communicate this to users, to auditors, to regulators, and to show that the way you are applying your security requirements, your security protocols, your data privacy protections has to be done in a transparent way. There are increased requirements in terms of what your privacy policy needs to say on your website. And for those who have sought Privacy Shield certification, you will have experienced probably a conversation or two with the Department of Commerce of aspects of your privacy policy that had to be changed and modified to fit that regulatory regime. Your terms of service need to be very clear in terms of, here is what I'm asking for, here's how I'm going to secure your data when I have it, and here are my limitations, my indemnification obligations, my limitations of liability. And so it's always wise to look at the terms of service to see what is the limit that this entity I'm dealing with and want to trust online. What limits are they putting in terms of limiting their liability back to me? Now, of course, under some of the regulatory requirements, some of that liability cannot be limited, but by and large, there are quite a few ways that you can still limit your liability, either through your privacy policy, through your terms of service. So you need to be aware of that as to how to protect your company. But on the flip side, you need to be aware of that if you are using dealing with a company and having to go through their online presence in order to get what you want. And then lastly, the access control and the data protections and the data security really need to be done by design and by default. They're specifically, again, to refer to the GDPR in the EU, because it is some of the most advanced regulations that are out there, and there's a body of work that sits behind that has gone back 20 years with the EU directive and is now being embraced in the GDPR. The whole idea of privacy and security by design, by default, is something that every company needs to be looking at. Simply going to the days of having some perimeter security, of some occasional encryption or protection of data in a less than fully thought out, meaningful way is going to leave you in some potentially bad straits going forward. So as we look at access controls, this being the key to being able to achieve both security and privacy. Historically, privacy has been a combination of policy and procedures. There isn't a lot of robust technology out there that has addressed this dynamic nature of privacy. Data security has always been, or is been pretty much a combination of policy, procedure, and technology. Again, with this overlay that all of these controls need to be accountable, provable, and auditable. So for those of you who have depended on a risk and compliance team that has a lot of policies and a lot of testing and being able to go to a regulator and say, well, all of our employees take privacy training, so we check that box. All of our employees take security training, so we check that box. Those are still critical aspects that need to be there. But as your company grows and moves more to the cloud, more to technologies that enable mobile, tablet, and more as you leverage data in your day-to-day business, you're going to have to also supplement this policy and procedures with technology, because you simply can't hire enough people and you cannot eliminate the human error element out of relying totally on policies and procedures. So I'm gonna stop there. I've talked for quite a while here, and I would love to have some questions to see if what I've talked about at a high level is helping address some of the concerns or some of the reasons you came to this webinar hoping to hear about privacy and security. So if I have any questions from the audience, I would ask that you submit them now, and I'll wait a couple seconds here while I see if any have come in, and then address those. So I do have a couple questions. First question that I see is, who is responsible to check for data integrity? Is it the consumer or the company? By and large, I would say that this is a shared responsibility, but the first aspect should be, if you are submitting data to a site, you need to make sure that that the data you have put into this site is showing up the way you want it to. And if a site does not have a way for you to be able to check whatever data you input, you should be inquiring at that company as to how you go about that and how they check to make sure. If that site is going to a third-party site, like a credit reporting agency or someone like that, you are going to have to depend on that, and I know that a lot of the credit reporting agencies have ways where if you disagree with the data that they're relying on, you have ways to question that and to ask them to correct that. I have another question here. Where in the organization should privacy and security fall to help ensure that the groups work together? This is an interesting question. You know, historically, data security has fallen in the entity within the realm of the Chief Information Security Officer, or the CISO, or the Chief Information Officer, the CIO. And historically, privacy has tended to fall under the guise of the legal department, either the Chief Legal Officer, or if the company has it, a separate privacy department and a Chief Privacy Officer. So part of what needs to start to happen here as there is this challenge of both data privacy and data security is these groups have to really come together and start to work together. In fact, if you look at, and I know I keep referring to the GDPR, but it is one of the best bodies of information out there. The GDPR, which again goes into full effect in May of 2018, provides that a company designate a DPO, or Data Protection Officer. And note that they are using the word data protection to really encompass the idea of data security and data privacy. So if you are a company that has over 250 employees, you need to designate a Data Protection Officer, or DPO, and you also need to have pick a country or region of a country in Europe where the Data Protection Authority of that region can come to you and make sure you are in compliance with GDPR. So this really forces and unites these two ideas of data security and data privacy under one umbrella of a DPO. As I noted before, there's a proposed law in New York that applies to financial institutions and applies to insurance companies doing business in New York, which is most of them, and it requires that, or it contemplates, it's not fully approved yet, that there will be a CIO for cybersecurity. So again, as the requirements under this New York proposed regulation touch on security, touch on privacy, touch on encryption and other protection aspects, it also calls out to have a unified position to start to address this. If you have other questions, I would ask that you submit those now as well. Question I have now is what are some of the trends that we're seeing in terms of supply chain and vendor requirements for data security and data privacy? I would say that this is one of the hottest areas that I'm seeing in terms of traditional companies that are regulated, banks and financial institutions, are now starting to look to their supply chain and requiring that those suppliers also comply with the particular data security, data privacy regulations that will apply to that bank. So in essence, a relatively small company that starts out as a non-regulated entity, but who serves a lot of financial institutions, insurance companies, or other healthcare, other regulated industry, are going to find themselves essentially regulated, because through contract with that bank, with that hospital, with that insurance provider, are going to be required to adhere to and sign up to the particular controls and regulations that apply to that entity. So as a cost of doing business for vendors in the space, that's going to be an ever-increasing line item that will have to be considered. Another question I got, how important are the certifications like ISO for vendors? I actually have a report here, an Ernst & Young report, that shows more and more, and this is probably more to look at the trends than it is the particular percentages. 39% are saying that they are requiring their vendors to be ISO 27001 certified. 33% are requiring PCI DSS certification and compliance. And of course, those are areas where you are dealing with payment cards and the like in that industry. 32% are requiring a SOC 2, which is a AICPA accounting-based special audit that is done to look at your standard controls and have a third party assess and review and pass on those controls and then issue a report, not unlike a financial opinion that you would get for your financial statements. So, are there any other questions? I think I've tried to touch on, as I said here, does this help you with your quest? Is this a true quest with King Arthur and the Knights trying to find this Holy Grail where I can address security and privacy? Or is it a bit of folly from time to time? It certainly feels that way, akin to those of us who are old enough to remember Monty Python, the Holy Grail. I do have one more question. Do you see the SAS 70 being reinforced with privacy and security issues? Again, the SOC 2 report, I believe, looks back 6 months, and so the special SAS 70, SOC 2, similar AICPA-based specific audits around data security and privacy, as indicated in the E&Y report, close to a third of companies are now requiring their vendors to adhere to some sort of specialty audit and specialty report to address these. Well, if there are no other questions, I want to thank everyone for participating, and hopefully you found this to be helpful. I've put my email address on the questions line, so feel free to reach out to me if you have specific questions that I might be able to address. And I hope you found this valuable, and thank you very much for attending today.